Hello, dear students. I'm Swati Singh Parmar, Assistant Professor, Dharmashastra National Law University, Jabalpur. And I'm here today to discuss with all of you international law portion for your preparation in CLAT UG examination. So the international law questions in CLAT UG exam are diverse, and there are various sections within international law that one has to prepare for examination purposes. So out of different sections, today we'll discuss only one of it, and that is relationship of international law with municipal law. But before we start our discussion, let us see what is international law and municipal law. International law can be loosely understood as a legal system. Legal system would be a set of legal principles, rules, and norms. International law is a legal system that governs the relationship between various states of the world. When I use the word states, I mean countries or nations of the world. So how different states of the world will interact with each other in terms of their political, economic, social relationship, that is governed by a legal system that we know as international law, right? So international law is above, in that sense, international law is above the state law. By using the word above, I do not mean a hierarchy between them. I just mean that state laws are there, and above state law in terms of governing the relationship between states is international law. Now, what is municipal law? Municipal law is the national legal system. Any legal system within the state is known as municipal law or domestic law or state law or national law. So municipal law can be interchangeably used with domestic law, national law, local law, etc. The examples of municipal law would be Indian legal system, containing all the civil, criminal, personal laws that are applied within the territory of India. Another example would be Sri Lankan legal system, Bhutanese legal system, Nepalese legal system, etc. So we loosely tried to look at what is international law and municipal law. We'll look at international law in detail in our other lectures. But for the purposes of this discussion on relationship between international law and municipal law, we know what is international law and municipal law, at least vaguely. So now let us begin with our lecture. So today, while discussing relationship, we'll first introduce the topic, then we'll look at the relationship, then we'll talk about dualism in detail, and after all our discussion, we'll have a look at passage and a few questions from previous year, so that it helps all of us understand whatever we have discussed so far illustratively. So let us see relationship between international and municipal. Now, from the point where we discussed about what is international law and municipal law loosely, we'll see that international law governs the relationship between states in terms of trade, economic, political, other matters, while each state also has a municipal, local level legal system. So do these legal systems, the state legal system as well as international legal system, interact? Yes, they do. So international legal system and the state level legal system, that is municipal law, they interact at several junctures. For example, if we talk about human rights. So international human rights has a lot of set of documents that are known as conventions or covenants on various human rights. Now, the international human rights law interacts with national human rights legal system. And you see that most of the legal systems of the states are in different degrees conditioned by international human rights law. Similarly, there are trade-related laws, internationally as well as nationally. The national level trade-related laws and policies condition and in a way affect the international law on trade and investments. So these interactions keep on happening, and these interactions are not one way but usually two way. International law conditions municipal law, and municipal law also conditions international law. Now, in simplistic terms, to understand the relationship between international law and municipal law, we have at hand two theories. One theory is known as dualism, and another theory is monism. So what is dualism? Dualism, by the name itself, is duality, some kind of duality. And in this backdrop, it is duality of legal systems. Now, when we say duality of legal systems, that means that international law is different from municipal law. So, dual legal systems, these are two different legal systems. That means that international law will be treated differently from municipal law. And what is the rationale of dualism? So, dualist, those who follow dualism or those who propound dualist tradition are known as dualist. So the state which will follow dualism will be known as a dualist state. So dualists argue that international law and municipal law are entirely different in their nature and characteristic. And since they are entirely different, that is why they have different effects. So, for example, municipal law will affect individuals of a state. For example, Indian Penal Code, now changed, will affect the individuals within the territory of India. The family law in India would affect the Indian individuals, except for in situations where we talk about Hindu Marriage Act, which will affect any Hindu outside India also. Or the Contract Act, Indian Contract Act, will be applicable for Indian citizens, right? So in that sense, municipal law far or less affects the individuals of a state. But on the other hand, let us come to international law. International law, as the definition I shared with all of you, if you recollect that, international law is a law that governs the relationship between various states in their interaction with each other. So in that sense, international law affects the states. So municipal law deals with individuals while international law deals with states. Now, in this sense, individual is the subject of municipal law. Subject is an entity upon which a law, a piece of legislation applies. So for municipal law, the subject is individual. Municipal law applies on individual. That is why individual becomes the subject of municipal law. While on the other hand, as we just discussed, international law affects the states, and that is why the subject of international law would be states. Now, this argument that the subject of international law is state, while on the other hand, the subject of municipal law is individual, and the fact that international law and municipal law are entirely different in their nature and characteristics, these two logics make dualists argue that international law is very different from municipal law. And once you say that these two legal systems are different, what happens? It entails that international law cannot be readily applied in the courts where municipal law can readily be applied. Now we'll look at this point. I'll leave this point here because we have to discuss about this point in detail. But first, let us see the other theory that describes the relationship between international law and municipal law. So the other theory is known as monism. What is monism? Monism etymologically comes from the word mono, and mono, as all of you would know, is oneness. So here monism means oneness of legal systems. That means that international law and municipal law are seen as one legal system. They may be different parts, but then different parts of one integral legal system. Now, monists, those who follow monism, monists argue that international law and domestic law are like branches of same tree, and they are not very different in the sense that international law as well as municipal law directly or indirectly apply to individuals. So we discussed that municipal law, the subject of municipal law is individuals, and international law, the subject is states, as argued by the dualist. Monists would argue that, okay, the subject of international law is state, but then within state, there are individuals, and international law's application ultimately affects the individuals. So in that sense, international law indirectly applies on individuals. So directly or indirectly, both the laws are applicable on individuals. That makes individual the subject of both the laws. So ultimately, it is the individual by trickle-down effect who is effectuated by either international law or municipal law. And therefore, these two legal systems are not very different from each other, but they are like branches of the same tree. Now, all this said, what will be the implication of this? Monist view of international law and municipal law as one, as mono, would mean that both of them are at same pedestal, and therefore, in the courts of law, the national courts of law where municipal law is applied, international law can also be applied readily. So, in a monist state, the states that believe in monism, their courts will apply international law readily as they apply municipal law. So international law will be applied readily or automatically as they apply municipal law. But on the other hand, the dualist states will not readily apply international law because they see international law as distinct from municipal law. So if they do not apply international law readily, how do they apply international law? Now that brings us here. So we'll look at how international law is applied in dualist. Before this, the implication that we discussed on international law being readily applied and international law not being readily applied also has one ramification. Where you say that international law will be readily applied in a monist state, that means that domestic law and international law are at an equal platform. So there is no subordination between international law and domestic law. Monists do not regard that domestic law is primary and international law is secondary, or domestic law is international law is not subordinate to domestic law, or it is subordinate to domestic law. Rather, they believe in same equal platform on which international law and domestic law are located, which is why the courts, the national courts, can apply domestic law as well as international law, and international law can be applied readily. But on the other hand, if we talk about dualist, the second diagram here that explains the view of a dualist between domestic law and international. So domestic, in case of a dualist state, the courts will give primacy to domestic law. They will say that domestic law is our national legal system's law, and that is why we'll apply it readily. And international law cannot be applied readily. In that sense, international law is different. So international law, any resort to international law will not happen automatically in that sense. Now let us move to dualism in detail and see how things work in a dualist state. So in both the countries, the countries that follow dualist tradition or the countries that follow monist tradition, the country has to first sign and ratify an international convention. And once an international convention is signed and ratified, then in case of monostate, the international law in that convention can be readily applied by the courts of monostate. While in case of dualism, there has to be one extra step that's taken for international law to be applicable in the national courts. So what is that extra step? Let us look at it. So when, as I said, it first starts from the point when a state signs and ratifies an international convention. And once a state, suppose state A is a dualist state, and it signs and ratifies an international convention, then, so signing and ratification usually happens at the end of the head of the state or a person designated to act on behalf of head of the state. After the signing and ratification has happened, the international convention that has been signed and ratified is brought to Parliament in terms of a bill. Bill, when passed by the Parliament, becomes a legislation. So a bill is drafted that carries the principles that are there in the international convention, the same principles, but with a national touch in the sense of platform, enforcement, the remedy process. So procedural requirements attuned to the national legal system are done, and this drafted bill is presented in the Parliament. Now, once it is presented in the Parliament as a bill, if it passes, then it becomes a piece of law. It becomes a legislation. And this legislation still has the legal principles embodied in that international convention that is signed and ratified. But now this legislation is domesticated. It is fine-tuned to the national legal system. And now it becomes a national legal system. So a part of national legal system. So now that it becomes part of legal system, it can be readily applied as law by the courts of that dualist country. Now here what happens? Because international convention legal principles embodied in that convention are in a way translated to national legal system, or are in a way adopted to legal system, or are incorporated in legal system. That is why we know this process of translating international convention, international rules in that convention into national rules as transformation, adoption, or incorporation. So these three are also three different theories that describe how international law in a dualist state is translated into national law, right? So for example, we can understand this as if in a school level example, if I have to oversimplify, if what happens during a school inspection. So the principal does not directly come to each and every class to inspect, or the inspection team would not directly come to each and every class, but inspection team or the principal may decide that the class teacher will take copies or books of students and then submit it to the office of principal, and then that copies may be checked. So what is happening in this process? There is class teacher who is acting as a medium between the principal or the inspection team and the students' work. So similarly, the international law here is interacting with individuals, is being applied for the individuals in the courts of law for dualist state, but that happens through the agency of transformation or adoption or incorporation that happens when international law is domesticated by presenting a bill, fine-tuning the international legal principles into the national legal rules, and then it being passed as a law. So now that we understand the basics of relationship between international law and municipal law, and we've seen two theories that explain it. Let us now see some fact-based situations. So this is one passage which is from CLAT, December 2022, and the passage reads as, there are two principal theories on the relationship between international law and domestic law, monism and dualism. The monistic theory maintains that the subjects of the two systems of law, that is, international law and municipal law, are essentially one. The monistic theory asserts that international law and municipal law are fundamentally the same in nature and arise from the same science of law and are manifestations of the single conception of law. The followers of this theory view international law and municipal law as part of the universal body of legal rules binding on all human beings collectively or singly. In a monist system, international law does not need to be incorporated into domestic law because international law immediately becomes incorporated in domestic legal system upon ratification of an international treaty. According to this theory, domestic law is subordinate to international law. The statute of International Criminal Court, therefore, can be directly applied and adjudicated in national courts according to the monist theory. According to dualism theory, international law and municipal law represents two entirely distinct legal systems. That is, international law has an intrinsically different character from that of municipal law. International law is not directly applicable in domestic system under dualism. First, international law must be translated into state legislation before the domestic courts can apply it. For example, under dualism, ratification of the statute of International Criminal Court is not enough. It must be implemented through state legislation into the domestic system. Most states and courts presumptively view national and international legal systems as discrete entities and routinely discuss in dualist fashion incorporation of rules from one system to the other. So this is the passage, and let us look at the questions that were asked based on this passage. So let us go to question number 1. It says, in light of the given passage, which of the following statements is correct? Monism and dualism are similar approaches to adopt international law into domestic law. B. Dualism postulates the homogeneousness of domestic law and international law. C. Monism and dualism are different approaches to understand how domestic law impacts international law. And D. Monism postulates the homogeneousness of international law and domestic law. So take a moment to read all the options, and then we'll discuss what could be the correct answer. Okay, so if we start with the first option, monism and dualism are similar approaches to adopt international law into domestic law. This clearly is a wrong answer. If we look at option B, dualism postulates the homogeneousness of domestic law and international law. That is, dualism says that domestic law and international law are equal, homogeneous. That would again be a wrong option. Third, C, monism and dualism are different approaches to understand how domestic law impacts international law. So these are different approaches. Yes, they are different approaches, but they make us understand how domestic law impacts international law? No, because it is more on how international law is implemented at domestic law level. So therefore, C would be wrong. D, monism postulates the homogeneousness of international law and domestic law. Yes, it postulates that international law and domestic law are more or less the same. So that is why D will be the correct answer. Now let us move to question number 2. It reads, X is a developing country. X ratified the United Nations Framework Convention on Climate Change in 1995, which will be an international law document, and incorporated the provisions of the said convention in its domestic legislation addressing climate change in 1996. However, X has been widely criticized in the international community for its failure in meeting the obligations under the said convention. Y is a developed country. Y ratified the United Nations Framework Convention on Climate Change in 1995 and has not incorporated the provisions of the said convention in its domestic legislation till date. Y has been appreciated by the international community for its success in meeting the obligations under the said convention. In this given situation, which of the following statements is correct? So let us see at the options. Option A, X is a monist state and Y is a dualist state. Option B, X is a dualist state and Y is a monist state. Option C, X and Y both are monist state. And option D, X and Y both are dualist states. Now we have to see two important highlights in this question. First, the word incorporation, incorporated. It says that X has ratified this convention and has incorporated the provisions of this convention in its domestic legislation. This means that X is a dualist state. The second highlight of the question is that Y has signed and ratified this convention. Y has not incorporated this convention, but still Y is appreciated for meeting the obligations of this convention. That means that Y, without incorporation of this convention into a domestic legislation, applies the convention directly. That means that there is automatic application of international law in the domestic courts of Y. That makes Y a monist state. So these two highlights would give us clue to the correct answer. So X is a dualist state and Y is a monist state is the correct answer. X is a monist state? No, because it incorporated the international law legal principles into a domestic legislation. Then X and Y both are monist? No, because Y has not incorporated and still is applying international law. That makes Y monist. And X dualist. X and Y both are dualist? No, because Y is monist, as we just saw. So that makes B, option B, X is a dualist state and Y is a monist state, the correct answer. Now let us move to the third question. The third question reads as D, a dualist state has signed and ratified the agreements on trade-related aspects of international property rights, which also is known as TRIPS agreement in short. An international agreement administered by World Trade Organization, WTO. If B is compelled to fulfill its international obligations under the TRIPS agreement, which of the following statements is correct? A, D may adopt the provisions of TRIPS agreement without enacting a new domestic legislation or amending an existing legislation. B, D may not incorporate the provisions of the TRIPS agreement into a new domestic legislation. C, D must incorporate the provisions of TRIPS agreement into an existing domestic legislation or in a new domestic legislation. And D, option D, D may not incorporate the provisions of TRIPS agreement into an existing domestic legislation. So a dualist state, in order to apply international law, has to either create a new law or to amend an existing law to incorporate those international law principles, right? So D here, the first sentence of the question itself gives you a clue that D is a dualist state. If D is a dualist state, that would make it a compulsion to transform these TRIPS agreement related international rules into its domestic legislation. So let us look at the options now. Option A, D may adopt the provisions of TRIPS without enacting a new legislation or amending an existing legislation. No, that cannot happen because D is not a monist state. Option B, D may not incorporate the provisions of TRIPS agreement into a new domestic legislation. So it says D needs not adopt this international law into a new domestic legislation. Does not sound right because again it's a dualist state. Let us look at the third option. D must incorporate the provisions of TRIPS agreement into an existing domestic legislation or a new domestic legislation. Yes, it has to incorporate the international law provisions into existing domestic legislation or create a new domestic legislation because D is a dualist state. So C is the correct answer. Let us also look at option D. D may not incorporate the provisions of TRIPS agreement into an existing domestic legislation. Again, is a wrong answer because it may not incorporate. No, it has to incorporate because D is a dualist state. So that makes us tick at C as the correct option. So C here would be the right answer. Now let us look at question number 4. So question number 4 reads as, which of the following statements is incorrect? A, according to monism, the nature of domestic law and international law is same and domestic law is subordinate to international law. This is correct. B, according to monism, ratified international convention automatically becomes a part of domestic law and domestic law is subordinate to international law. This again would be correct. C, according to dualism, ratified international conventions automatically become part of domestic law and domestic law is subordinate to international law. This is wrong, completely wrong, because a ratified international convention automatically does not become part of domestic law in case of a dualist state. So this is wrong. Domestic law is subordinate to international law. No, dualists treat domestic law superior to international law. Therefore, domestic law is readily applied and international law is not. So C, both parts of option C are incorrect. Let us look at D also. So option D says, according to dualism, the nature of domestic law and international law is different. Correct. And domestic law is not subordinate to international law. Correct. So D is correct, B is correct, and A is correct, and C is incorrect. That is why we'll choose option C as the answer to question number 4. So let us look at the next question. This is question number 5. It reads as, the country X has ratified an international convention which requires each state party to enact laws defining and punishing bribery. That is, the act of offering bribe to government officials. The convention has neither defined bribery nor prescribed a punishment for the same, so that each state party may define the offense of bribery differently in their respective domestic legislations. By 2022, X has not enacted any law defining and punishing the offense of bribery. In November 2021, Mr. A was being prosecuted by a domestic criminal court in X for allegedly offering a bribe to a government official. In the given situation, which of the following statements is correct? Option A, if X is a monist state, Mr. A can be punished for committing an offense under the convention. Option B, if X is a dualist state, Mr. A can be punished for committing an offense under the convention. Option C, if X is a dualist state, Mr. A cannot be punished for committing an offense under the convention. Option D, Mr. A cannot be punished for committing an offense under the convention, irrespective of whether X is a monist or a dualist state. So let us go back to the question. Country X has ratified this international convention, right? This international convention requires state party to enact laws on punishing bribery. States can define bribery according to their own respective domestic legislations. Fine. And X has not enacted or defined bribery. Now let us look at these. If X is a monist state, A can be punished for committing an offense under the convention. Correct. If X is a dualist state, A can be punished for committing an offense under the convention. No, because domestic legislation has to be there for an international law convention, so that international law convention's principle can be readily applied. C, if X is a dualist state, Mr. A cannot be punished for committing an offense under the convention. Mr. A can be punished under the convention if a law is created, right? So till now, A seems to be the correct answer. And D, Mr. A cannot be punished for committing an offense under the convention, irrespective of whether X is a monist state or a dualist state. So all these three are wrong options, and answer would be option number A, which says that if X is a monist state, Mr. A can be punished for committing an offense under the convention. So I believe that these 5 questions based on the passage from CLAT 2022 question paper are clear to all of you, and they have made all of you understand what is the relationship shared between international law and domestic law. And I will ask all of you to read more on relationship between international and municipal law in terms of certain examples and illustrations that you can find from previous year question papers, because after our discussion today, there are many areas within monism and dualism that may be more clear to all of you now. So now that we have discussed various points about relationship between municipal law and international law, it will be very helpful if you could look at previous year question papers and try to solve the questions based on relationship between international law and municipal law. So we'll end our discussion today. Thank you.